Welcome to the Three Questions webcast series. I'm Wayne Baxter, Senior Executive Manager with One Capital Management. On this edition, we're going to ask the three questions Canadian citizens and U.S. residents should ask if they own property in Canada. Thank you for taking the time to check us out. And if you enjoy this episode of the Three Questions webcast series, please consider liking this video and subscribing to our YouTube channel. My clients are often referred to as cross-border clients. Why would that be? Well, it's because they're either U.S. or Canadian residents who invest in U.S. and or Canadian dollar-denominated securities like stocks, bonds, or ETFs. At One Capital Management, we develop and implement strategies that strive for our clients to grow, protect, and ultimately distribute their wealth. And we do that by offering investment wealth management services. Our process for advising our clients includes an in-depth discovery and diagnostic analysis of their wealth management goals and objectives. And as one would expect, that analysis will include a review of their estate planning strategies. In this episode of the Three Questions webcast, we're going to take a closer look at questions a Canadian citizen, U.S. resident, who owns property in Canada may want to consider. On this edition of the webcast, we're going to cover the three questions a Canadian citizen, U.S. resident should ask if they own property in Canada. Joining me from Pasadena, California is Andrew Nutbrown. Andrew is an associate attorney with KJMLAW Partners. He primarily handles trust administration and estate planning with a focus on developing comprehensive estate plans for high net worth individuals in both domestic and international property interests. Now, Andrew is a fellow expat Canadian like myself, and given the topic, he is a perfect, ideal contributor for this episode of the Three Questions webcast. Andrew, great seeing you. Great seeing you again. Thank you for making time to joining us today.
Great. Thank you. Happy to be invited.
Right. Well, listen, we got a lot to cover here. And before we get to our three questions, I think we should really just first clarify what kind of properties you find yourself dealing with when working with Canadians who have relocated to the U.S. Just give you an example of maybe two or three.
Often what I see are people who've moved down for work or just really trying to escape the winters up in Canada. And often they have, properties, some family cottages back home in Canada. And they might have some assets, some liquid assets, bank accounts, RRSPs, and all of those types of assets that still remain in Canada. And often they've opened up new U.S. accounts and purchased properties and are living there. But there are obviously ramifications for keeping Canadian assets, especially when in the unfortunate event where someone passes away and those assets still exist in Canada. So
I guess we should also probably include in that list, I mean, as far as property goes, as inherited property as well would probably be also something where
right.
We get the email or the phone call from the client letting us know that they've inherited assets from their parents. I know you and I have worked on a couple of cases like that here recently.
Absolutely.
But again, thanks for clarifying. All right, just to help us for folks understand when we're talking about property. So it could potentially be real estate, it could be liquid assets, basically.
Right.
That's right. Okay, so let's take a look at the three questions a Canadian citizen, U.S. resident should ask if they own property in Canada. And the first one, question number one, assuming that I continue owning Canadian properties, how will my estate be taxed in the U.S. and Canada when I die? Andrew, over to you.
Yeah, so the U.S. and Canada employ entirely different tax regimes. So in the U.S., when someone passes away, there's three types of taxation that are often relevant. There's estate taxation, which is a tax based on all of the U.S. domicile or U.S. citizens' assets, no matter where it's located throughout the world. And that would apply to a Canadian citizen who's then living and domiciled in the U.S. There's also gift tax, which is a tax on any gifts made during their lifetime, which has an impact on the amount of exemption available for estate tax. And there's also generation skipping transfer tax, which is a tax on any transfers more than one generation below the decedent.
So grandchildren, for example, will be an example.
Grandchildren, for example, or someone that's more than 35 years younger than them if they're not related. In Canada, there's actually technically no estate tax in the sense that there's no taxation on the value of the assets like there are on death, like there is in the US. Instead, there's two main types of taxation we see in Canada on death. The first is you're deemed to have disposed of all of your assets.
In the
And
year of your death, right?
yep, on the year of your death, and that causes a deemed disposition, and that triggers capital gains on all of the taxation.
That's not, and that excludes the RSPs and risks we should add, and that's
Right.
taxed
Yeah,
differently. We can get
it
into
excludes that. It also excludes your principal residence, but if you're resident in the US, then that won't apply. The other type of taxation is provincial taxation. And for most provinces, there's estate administration tax, which is applied on the value of all of the assets that are submitted to probate, that court proceeding where you're able to administer your assets as part of the estate. And that's a lot lower. It's normally around up
Is
to
it 0.5 on the first 50,000 and 1.5 on the remaining, if I get that right?
Yeah, in Ontario, it's like that. So it's at most about 1.5%, but it's still an extra tax that people have to go through.
Probate tax, basically, they used to call it one back in the day.
Yeah. So the big difference between the two is there's generally there's no real exemptions in Canada apart from some exceptions for your principal residence and assets that are gifted to your spouse. In the US, there's a very large exemption for US domiciles or citizens that's right now about $13.5 million. So it's quite significant. And so that's typically how estates are taxed on passing. One other key difference is that trusts are disregarded entities. Revocable trusts are disregarded entities in the US, so a lot of state plans use those. And in Canada, that's not the case. There's only some limited exceptions, and the general rule is that trusts are taxed at the highest marginal rate. The exception being testamentary trusts, which I'm sure we'll get into later.
Right. And I guess the other difference between trusts in Canada and the United States is that trusts in the United States tend to last a lot or can stay in force a lot longer. Where in Canada, now you're the expert here, but based on my experience, they have to be restarted or renewed or collapsed after 21 years.
Yeah, every 21 years, there's a deemed disposition, similar to the deemed disposition when someone passes away. So that again triggers capital gains tax. In addition, you typically now want your Canadian estate to be a graduated rate estate. And so that only applies within right now the first 3 years. So often Canadian estates are administered, normally you're trying to get everything done within 3 years. And that serves two purposes. The first, for all the assets that are being transferred to the spouse, you want it vested to the spouse within 3 years so that you have that exception to the deemed disposition rule for gifts to the spouse. And also because you want to keep the graduated rate estate rather than having income tax at the highest marginal rate. So yes,
Well, the plan
very
was
different than the US.
like very much so. Again, the key part is that Canadian trusts have a bit of a much shorter gestation period, most definitely. Now, okay, thank you for that. Now, this perfectly segues into question number 2, and that is, what type of an estate plan should I have for my U.S. and Canadian assets? Again, we're talking about a Canadian who has property, or a U.S. resident Canadian citizen has property in Canada. So, Andrew, over to you.
So for this type of person, it makes sense to have an estate plan where the Canadian assets are dealt with differently. And the reason why is because Canada will tax all of the Canadian situs assets. So like the family cottage, for example, is a perfect example of that. And so you would not want the Canadian cottage to be put into the same type of estate plan as a US estate plan for all of your
100%.
US assets, because you will be faced with the income tax issues if there's actual income being generated from that cottage. But also you'll have the deemed disposition impact as well, because a lot of the US trusts, the estate plans will typically be through a revocable living trust often. And then after you pass away, that trust will have provisions where it's designed to ideally avoid the beneficiary from having those assets included in their taxable estate when they pass away, and so on and so forth, because you're trying to avoid them from being from having to pay estate tax and or generation skipping transfer tax when the assets go down to the family members. So those type of trusts, although they make great sense in the US, are terrible in the Canadian tax system because of the deemed disposition rules and whatnot. So often what we end up doing is we have a US estate plan, and then for the Canadian assets, you'll want your own separate estate plan where that deals with testamentary trusts. And there's another advantage too, in that you can have what's called dual wills in Canada. And this is an estate plan that's aimed at avoiding, to the extent possible, estate administration tax, that provincial tax on all of the assets submitted to probate. And so essentially what that involves is creating two separate wills. One will limited to all of the assets where you require a certificate from the court in order to deal with after someone passes away. Mm-hmm. So an example would be like bank accounts, some types of real property, those types of assets. And then you'll have an entirely separate will that will carve out all of the assets that you don't need that certificate to administer. And the biggest example would be shares in private companies. Personal property, often you don't need a certificate, let's say, to give your jewelry to someone else. And certain types of real property, particularly in Ontario, you can put in these types of wills without having to pay estate tax generally, or estate administration tax generally. And that avoids having to pay that 1.5% on potentially quite significant valued assets, especially when we're dealing with corporate shares. If there's a lot of Canadian corporate shares that have a lot of worth. So that's often how these estate plans are structured in Canada generally, and Ontario in particular. Each province, of course, is slightly different, but a lot of them employ the same type of provincial estate administration.
Now, one of the things in the past, in working with cross-border clients and they're dealing with their cross-border estate plans, it was important that the US and Canadian attorneys, assuming there's one in both countries, I know you have the benefit of, well, I should have mentioned maybe at the beginning of our webcast that one of the great things about Andrew is that he's licensed to practice law in Ontario and right. Here in California. So it's a rather unique licensing ability, but most oftentimes, a client will come to us and they'll have an estate planning attorney, say here in California or whatever other state they live in, and then they'll have another attorney in Canada. And it's important that they work together and that the U.S. estate plan document sort of acknowledges that the client has assets in Canada. They kind of have to talk to each other, and I guess it'd be a simplistic way of putting it. They have to in other words, the U.S. estate plan should acknowledge the assets that are domiciled in Canada. And I would assume there had to be some similar wording in the Canadian estate planning documents to acknowledge that the client is a U.S. resident.
It's definitely important to define the scope, because and I've had cases like this, and it's very unusual, but unfortunately, I feel like this is going to continue to happen on a fairly regular basis. But I'll give an example. We had a client, their father passed away. They were originally from Ontario. They had a family farm. They moved down to the US and they had assets in Nevada and California and whatnot. They had a Nevada trust, revocable living trust, and often the US estate plans have a very simple will. And all the will basically provide for is that all of the assets are included in the estate are to be transferred to the revocable trust. Oddly enough, he prepared an Ontario will, and then around 2 months later, he prepared a US estate plan. And of course, the first line of the US will is I revoke all prior wills. And then
Oh,
so that, yeah,
no.
so a mess. And clearly there was no communication between the Canadian lawyer and the US attorney because they actually the beneficiaries were different. And so it was actually a very unusual dispute because it was unclear who are intended to be the beneficiary of the Ontario assets to the family farm in particular. Now that one, luckily, we were able to make work. But the other issue too is in a lot of Canadian provinces, pour over wills aren't even recognized as wills. There's a few more recent cases in one in British Columbia and in Ontario as well, where pour over wills were not recognized because it didn't meet the Canadian requirements of a will. But then there's some other provinces like Newfoundland where they are recognized. So it's a bit of an unclear issue right now, in my view. But I would say a lot, it's the use of pour over wills is widespread in the US. And so I think for a Canadian who's moved down to the US, you get a new estate plan. I think that you have to be really careful because often enough the sample type of estate plans that lawyers are using down here to will incorporate pour over wills and will include all of the assets no matter where they're situated. So and for someone who has Canadian assets and is living in the US, I think it's very important that their planners be careful that their documents are restricted to the intended scope of what it should apply to, and Canada limited to just that jurisdiction. So because a Canadian estate plan applied in the US is not a great estate plan, it's a terrible estate plan. And a US estate plan applied in Canada is also a terrible estate plan. So it's you've got to work together in order to get something that really is coherent. Yeah.
Well, I'm glad I asked that question and made that point. So, what we've done so far is covered the establishment of these estate plans, but now we kind of go into question number 3, and we're going to look at the other side of the coin here. So question number 3 of the 3 questions webcast today is, how should my estate be administered when I die? So now we're talking about, now we're at the point where there's a passing in the family here, and we've got to start administering the estate in both the United States and Canada. So how are they administered?
So the principles of administration are the same, although each jurisdiction has certain steps that you should be cognizant of if you're administering an estate. In the US, you might be required to file an estate tax return or a Form 706, and those have to be filed within 9 months of someone passing away. You can get an extension for 6 months, and in some circumstances, you can file up to 5 years, but those are only in very limited circumstances. You should try to get the estate tax return filed within 9 months, if that's required. And from the perspective of a Canadian, if you're a resident domiciled in the US, then the same rules apply primarily as if you're a US citizen as far as the filing requirement. But if there's a question about whether you're actually domiciled in the US, you definitely want to file within the time period because there's a different type of estate tax return that has to be filed if you're not a US domiciled or not a US citizen. And that difference is significant because the estate tax exemption in the US again, right now is around 13.5 million. If you're not a US domicile, that estate tax exemption is 60 grand.
Yeah, just going to say it's way lower.
Difference. If you have a house in Southern California, housing prices are quite significant. If you have $1 million house, for example, your estate tax exemption is only 60,000. The amount of estate tax liabilities is going to be in the several $100,000 range. It's around 40% once you reach that point where you're going to be liable for estate tax. Now, the filing requirement is important because for Canadians, you have the benefit of the US-Canada income tax treaty, where you can elect certain.
You're not double taxed.
Yeah, so you can avoid double taxation and you can, and for Canadians, there's a special type of exemption that's available that avoids those really tragic consequences where someone who, had they been a U.S. citizen and U.S. domiciled, wouldn't be exposed at all. But with the absent that treaty, they'd be in a lot of trouble. In Canada, the deemed dispositions are applicable to all the Canadian situs assets if you're not a Canadian resident. As far as the administration is concerned, you would want to file, you would want to get valuations on all your property similar to the US. You would have to determine the cost basis of all of your Canadian capital property, so you can determine what that capital gain liability will be. And then you file returns, and then you have to, best thing to do is to apply for a clearance certificate from the Canadian Revenue Agency so that you know you're fine from the perspective of someone administering the estate, and then you can move forward to distribute the assets. But definitely, if you're dealing with an estate that involves assets in multiple jurisdictions, it's really important to get someone who knows what they're doing in that specific jurisdiction, because the laws are different in different countries and in different states and different provinces. So it's important that all the steps are met, so you're not dealing with issues down the road.
Well, Andrew, I've had, we've done over, 50 some odd webcasts now. And, I've got to tell you right now, you are definitely providing a reaffirmation that estate planning is not a do-it-yourself process. And most certainly cross-border estate planning is not something you want to try to cobble together by using some documents off the internet. This is like very, very complex stuff. And really glad that we had a chance to meet. I do have one more question though, before we let you go real quickly here. For a Canadian citizen, again, this is a Canadian citizen who's a U.S. resident, they have property in Canada. When should they begin putting that estate plan in place? Like, is there a time, like, how would you, let's just, take it from the context that maybe they're just doing a relocation now, right? We'll assume that they haven't been down here for 14, 15 years or whatever. They are doing a relocation. It's like, what's the timing here?
I think it should be done right away. And especially if you are expecting to stay in the US for a considerable amount of time or permanently, there are a few unique opportunities that might be available, especially if you're expecting to inherit assets that are from Canada, from relatives and whatnot. There's a few opportunities there that aren't available to people who are in US citizens without inheriting any foreign assets. So it's definite, and absent planning in advance, those opportunities will be lost. So I think you really have to look at it, even when personal life changes occur, like someone's getting married, divorced, that has an impact sometimes on the validity of documents, depending on where you're situated or where those documents were prepared. So really any major change in your life, whether you're relocating to a different jurisdiction, entering into new relationships, having new children or whatnot, I think it's definitely worth putting emphasis on getting an actual estate plan together or revising an existing estate plan. I think sometimes it seems like it might not be worth the expense, but I think you have to take into consideration this involves all of your assets, your entire net worth, and the disposition of that. So it does have a big impact on maybe not your life, but definitely your loved ones. And
we covered a lot today, and I really, just listening to you, I can think of 2 or 3 different additional topics we could cover. But for now, for someone who's watching or listening to us today, and they would like to reach out to you because they say, wait a minute, this applies to me, what is the best way for them to reach you?
You can give our office a call or send an office our office or email. I've got my email address, I believe, that I can share.
Yes.
And then there's
So they can email you directly, and that'll work as well.
Yeah, that's fine. I can if for whatever reason it's something not in my purview, I'm sure I can lead you in the right direction or send it to someone at our office that can help. But yeah, that's probably the best. Email is probably the best way to reach me, or you can just give our office a call.
That's it. Nutbrown at KJMLAW.com. And we actually have that posted on the screen here, so folks will be able to see it. So again, thanks again to Andrew Nutbrown. Andrew is an associate attorney at KJMLAW Partners. He joined us today from Pasadena, California. Andrew, thanks a lot for making time for us today.
Thank you.
I look forward to bringing you the 3 Questions webcast, and I hope you find them educational and informative. Please consider liking this video and subscribing to our YouTube channel. And to receive a notification of our latest webcast has been posted, please click on the notifications bell. Lastly, to schedule a consultation with me to discuss your wealth management needs, please click on the link in the description box below, www.onecapital.com/meet with Wayne. Thank you, and we'll see you soon.